Mayor, you can proceed whenever you're ready.
All right, thank you. Thank you, Max, for managing this virtual meeting. It is Thursday, March 18th, 2021 at
Mayor, hold on 1 second. Please. You may go now. I'm sorry.
That's all right. Thank you, Max. It is Thursday, March 18th, 2021. This is a virtual special meeting of the Commissioners of the City of Rehoboth Beach. I'd like to call this meeting to order at 9:00 a.m. I'd like to start roll call. Commissioner Richard Byrne. He's here. Commissioner Susan Gay.
Here.
Commissioner Patrick Gossett.
Here.
Commissioner Pat Caluzzi.
Here.
Commissioner Jay Legree.
Here.
I'm Mayor Stan Mills. We have a quorum, 6 commissioners. We're able to formally conduct business today. I am hoping that Commissioner Sharnowski can join us shortly. He indicated that he would likely be here, but I also want to thank everybody. I know this was an inconvenience on such short notice, and some of you had to change schedules, so I thank you for doing that. Would like to make note of correspondence. You can see that some correspondence is embedded in the agenda. I'd like you to make sure you understand that that is not all the correspondence we receive. Per the Freedom of Information Act, we have a cutoff date where we can put correspondence into the agenda. All the correspondence received is part of the record, so I assure you that. We do have letters, by example, from Wesley Paulson and Gene Lawson and others on the ClearSpace, very clearly supportive of ClearSpace there. So I wanted to acknowledge that. I would like to make note of a memo which gives a reason for the special meeting today. This is a memo sent out, I believe, Tuesday to representatives of the appellants, Planning Commission, and ClearSpace. It indicates the following. This memo says, after much thought, I am convening a special virtual meeting on Thursday, March 18th at 9:00 a.m. The purpose of the special meeting is for the potential reconsideration of the April 8th, 2021 hearing date for the Rehoboth Spotlight ClearSpace appeals. This special meeting is called on less than 7 days' notice to address a March 15 request by appellants for an extension of the hearing and corresponding code-mandated brief submissions for the appeals. 7 days' notice could not be provided because by code, opening submissions are due on or before March 18th. If 7 days' notice of this meeting were given, the request for extension of the briefing deadlines would be moot. Further, the memo continues. I say, please note, do not be misled by the agenda. Each party desiring to provide submissions should still be prepared to provide submissions timely by the established deadline on Thursday, March 18th, should the commissioners decide to affirm the April 8th hearing date instead of establishing a new date for the hearing expected to be during the week of June 14th. No public comment will be allowed. However, correspondence is welcome. And again, I've made note of the correspondence we have received. I want to thank everybody for writing. I thought long and hard about reconsideration and convening this meeting. It's not something I take lightly, but I believe the reconsideration is the right thing to do. We could certainly have the same outcome. That's fine. But I feel better with the additional consideration by everybody again. In retrospect, I believe I could have better managed the March 12th meeting to schedule the hearings. I do believe that if I presented only the June meeting as the only date available, that we might have had a different outcome. I chose the April one because I thought the sooner the better. Silly me. Didn't prove to be that. So we'll see what happens today. I believe I was wrong. I also could have done better by offering multiple dates to select from, the April date as well as the June date, and that might have had a different outcome. Further, I believe I could have better explained the time prescribed in the code for providing submissions. It did not sink in, for me at least, that the 21-day window meant for this appeal for the April 8th date selected, that there would only be 4 days to prepare for the submission. So I see three possible actions that could occur today. Number one, we retain the April 8th date and submissions are due today by the close of business. That gives the everybody 4 days, 4 business days after the March 12th meeting, where we selected the date to file their submissions. We would, with retaining April 8th, retain Mr. Walton as our counsel. And we recall, if you recall, we mentioned during that meeting that we would convene the meeting at 2 o'clock on April 8th, and we must complete the hearing in 1 day because the council does not have any extra time after that. The other thing we could do is change to another future date. The earliest date beyond April 18th, beyond April 8th for the Board of Commissioners to use counsel Mr. Walton is June 14. This would provide for a second date of June 16 or 17, possibly, if we weren't able to conclude the hearing on June 14th. But that would give all parties more time to prepare. We also have a third option. That is to change to a future date between April 8th and June 14. A date in May seems acceptable to the appellants. We would need to seek new counsel and set a new date with counsel. To do this, we would need a motion today to nullify the April 8th date and then convene again in the near future after I secure a new lawyer. But can't guarantee that we can find new counsel and that they can meet the May timeframe. So the only sure thing is to possibly stick with Mr. Walton on June 14th. With that, I'd like to open the floor to the commissioners for discussion. Commissioner Gay.
Yes, thank you, Mayor. First of all, thank you for that explanation. I have to admit that I had not looked at the code. I hadn't really looked at much of anything before Friday. So I don't think you were alone in that. I don't think any of us did. And having looked at it afterwards and realized that the language does say that we would schedule an appeal hearing within 60 days or as soon thereafter as practical. And then also looking at the history of at least the 2 appeals that I've been familiar with the last few years. And one of them, the last one for Clear Space, was about 2.5 months. The one for Beach Walk was like 7 months. And, so my interpretation of that code language is that the expectation is around 60 days, but that it says as soon after as practical to allow for things like the situation we're in where a significant party is not available. So looking at the calendar, I immediately saw, that 60 days would be May 11th. And obviously, Max is not available till June 14th. And you just stated the very issues I was going to bring up, which is, do we want to, keep the same counsel or go 4 weeks later? But in my mind, that's kind of where we are. We're facing a 4-week delay, not any more than that, because it doesn't seem practical to me to keep the 8th. And so if we're looking at that, then we really are just a few weeks off from where we should be. I mean, personally, I think that Max brings knowledge to the situation because he represented us before, so he's knowledgeable. And as you said, bringing in a new attorney means we can't even settle it today. And I would love to be able to settle it today. So I might have more to say later, but that's my intro.
Thank you. Max, do you have a desire to explain the 60-day interpretation?
Yes. Ultimately, you're not required to schedule within 60 days. And one of the commissioners pointed out I may have stated something wrong at the last time we met on the fly, but you have to schedule within 60 days. You're not required to hold the hearing within 60 days. Obviously, I just want to say to the commissioners, I'm very sorry that this came at just a terrible time for me with a couple of 8-day trials in the middle. And this is my only option. I'm doing the best I can. So I apologize. But yes, that you can go beyond the 60 days if you so desire.
Thank you. Thank you, Max. Commissioner Legree?
Yeah, I'm guilty of making the motion to accept the April 8th meeting day. I wanted a speedy outcome. and I thought that both parties deserved a speedy outcome. And I think that retaining our counsel contributes to a speedy outcome. And so, but as we all having those decisions or making those decisions before reading the appeal petitions, you immediately the situation changed, and there is a heavy volume of work that has to be covered by the parties that are contesting this. So I wish to withdraw my preference for the 8th April meeting day, and I am ready to set a new date. And I know it's more than 60 days, but as Commissioner Gay, and I endorse all the things that Commissioner Gay said, we've done it before, and for everybody's fairness, I think it's better that we keep our we want this to go through and stop. We don't, whatever we do, whatever, if we say yes, if we say no, we want that to be satisfactory to everybody. And that's a tough bar to clear. But I believe postponing it until the June date is our best course of action right now. Thank you, Mayor.
Thank you, Commissioner. Is there anybody else that would like to talk?
Yeah, I will.
Commissioner Gossett?
Yeah, I just sort of want to echo some of the comments previously made. I think it's important to remember why we are and why we are not what we are not considering today. We're not reviewing the merits of this application. We're not deciding whether or not to take an appeal of the Planning Commission. The only question before us today, where consideration is whether the appeal provided for in our code will be heard on April 8th or at some later time, depending on additional information that we've received. And just to be clear, I wanted to cite the code because there's some misinterpretation out there, if you will. So we fall back to section 236(6)(a) subparagraph 1 of the code. And it says, upon receipt of the required written notice of appeal, the commissioner shall schedule an appeal hearing within 60 days or as soon thereafter as practical, where at that planning commission, the applicant or the appellant, if different than the appellant, shall be afforded an opportunity to be heard. The commissioner shall provide public notice of that hearing. And as been mentioned before, the aspect of a 21-day submittal of additional information is very important. This is, as we all know, this has taken some time to get to this point. There are thousands of pages of evidence, sketches, architect's plans, etc. Over 20 hours of oral history and testimony that are out there. So I think that based on that, and based on past practice of the city, with with Clear Space here, we've had motions that occurred November 12th, and that's been nearly 3 months after the appeal was filed. The Boardwalk or Beach Walk case, a motion to dismiss the appeal was rendered more than 7 months after the appeal was filed, and the final decision upholding the decision came more than 10 months after the appeal. So I think in further reflection and having heard from over 40 individuals from the city in the past few days, that the March 18th filing date for legal memos and the April 8th appeal hearing date are too short for our careful and deliberate consideration of the developments this complex and with such major implications to the city. I think this also really a change in date, which is proposed to currently June 14th, one of the options we're looking at, really provides due process for all parties, not just the appellants, but also the applicant, to be prepared for that. If we look at that 21-day window prior to the June 14th, that allows 9 weeks of time for all parties, including ourselves, to review and update ourselves on all of this voluminous information that's been submitted. And again, as has been mentioned several times, this theater complex has a major impact to the city on many aspects that we all need to very strongly consider. And that would come at a later time. But today is strictly looking at the date. And I do support the move to reconsider the date and move it to June 14th. Thank you.
Thank you, Commissioner. Commissioner Byrne?
Yeah, thanks, Mayor, and good morning, everyone. Well, with all due respect to the comments that have been made, I really want to speak to support and affirm the date that's already been chosen. It escapes me to see what the benefit to our community as a whole would be to delay this for 2 months. And then who's to say that it wouldn't or possibly be delayed again? I think delays are harmful, both costly in terms of dollars, harmful in other ways in terms of divisiveness in the community. The appeal is totally on the record. No new facts can be brought forward, and many of the letters that I read, and it's nice that so many people are interested in paying attention to what we and the larger community are doing, but many people, I think, are mistaken that we're going to discover all kinds of new information and new facts to come to bear on this case. And that is not the situation. The appeal is on the record. The record is what the Planning Commission has done twice. They have supported this situation going forward. So again, I think delays are costly. I think both parties, in Commissioner Legree's words, deserve a speedy outcome. I think that's fair. We affirmed a date a number of days ago, and I'm all for staying with that. Thank you.
Thank you, Commissioner. Commissioner Coluzzi?
Yes, thank you, Mayor. I would have to agree with Commissioner Legree that we're looking for a speedy to solve this issue quickly. And I agree with the comments of Commissioner Byrne. This appeal will be on the record. And as I have read the latest documents from our attorney or letter, there's going to be not more than 10 pages of information, which is basically, I guess, to look at what has been said in the past and what we've heard before. So I don't see where additional time is needed, that the 10 days, I'm sorry, that the 10 pages of information that they'll put together from what they've been working on over so many weeks and months anyway, it appears to me that as far as the cost to the city, and it's cost us a lot. It costs all of the city a lot. And I'm just really feel that it would be harmful to all parties to just continue to delay. So I am not in favor of changing the date. I'm in favor of keeping the April 8th date. And by the way, this particular meeting, I'm not sure, this was never not noticed properly in terms of 7 days. I do understand that it couldn't have been, but to the appellants should have raised at the time that they weren't happy with the date. We could have dealt with it on that day. And so that is my position. Thank you.
Thank you, Commissioner. Commissioner Gay?
Yeah, I just want to react to the issue of cost, but also the record, and it actually, to go with something Pat just said, I don't think the public was allowed to speak. That was part of the problem we had last Friday, is that we didn't have much information before us and no one was allowed to speak, or else perhaps somebody would have requested a later date then. But here's what I've been really struggling with the last few days is, if we can't find workable solutions here, the city faces legal action that could go on for a while, years. And to me, that's where the cost comes in. I mean, I want to find a solution that works for everybody. I very much want, Clear Space to be here. Ain't gonna happen. I'm trying to be realistic here. That ain't gonna happen if we rush it. It just flat out ain't gonna happen. And I think we need to recognize that.
So may I interrupt? Today, you guys are acting in a judicial capacity. Okay, you're not acting in a legislative capacity when you're hearing this. So today, we need to stick to whether or not you break Clear Space, you don't, whatever. You guys are acting judges. I don't mean to interrupt, but that's your role in this proceeding. So,
Thanks. I appreciate that. You know, the other thing I was going to say in terms of on the record, the first appeal, I don't know about the rest of it. I didn't study the record because we were dealing with all the preliminary motions. So the record is voluminous, and I understand there's no new evidence. I get that, but there's a lot already there. And I do get the sense that some new issues came up between the time of the first decision and the second. So, and those are on the record. So there is a lot to go through, a great deal to go through. And on the 10 pages, by the way, I thought I had read somewhere, I can't remember, it seems like it was in one of the letters or something, where they were asking to go beyond that time, you know, that go beyond that length for submission. So I don't know if we need to address that too. I certainly don't have an objection to it. On the other hand, you know, obviously we don't want 200 pages, so we have to decide something there. But I really think that that if we can wrap this up in 2 months, we will have saved the city greatly, and there's a lot to look at in that time. That's all.
Thank you. Commissioner Gossett?
Yes, I just, again, as Mr. Walton mentioned, in this role, we are acting as judges, judicial. And in that role, I want to be prepared for the issues presented to us. I mean, I think if we all go to a court of law and the judge has seen our case the day before, we all feel kind of shorted somewhat on involvement. And I think our role is to be accurate, careful, and responsible in reviewing this information. And there is a lot out there. Just the beginning, at the conclusion of our meeting to set the initial date, I started looking back over some of the information, the hearing notes, the minutes from the first appeal, the submission of data. And there's a lot out there that I want to be prepared for, to review this information. That is our role in this hearing. And I think if you look back at court cases around the nation, a judge just doesn't pick up the docket the morning of and make that decision. They or their staff or their law clerks or what have you really do a lot of research. And that is what our responsibility is for this hearing, in my part. You know, and I just don't think that the current schedule is in keeping with that ability for us to do that research and to give an honest, thorough review of the material, so we are familiar with what's going on and can make a clear decision. Thank you.
Thank you, Commissioner. Commissioner Calusi?
Yes, this question is for Mr. Walton. Mr. Walton, in our role as judges, I think what we are looking at, correct me if I'm wrong, is either affirming what the Planning Commission has decided, or for some reason deciding that they haven't done their job. Are we really looking, or are we looking at relitigating this case in some way by going through? I mean, I've listened to the meetings, I've read a lot of the documents, not everything, but can you give me some thoughts on that?
Sure. Last time you remanded, this time you cannot, under your code. You can affirm, and I don't have the code in front of me because I'm not in my normal spot today, but you can affirm, you can reject or deny, or you can modify the decision below, as my memory states. So ultimately, that's your role in this proceeding. There are special standards that you have to apply. I don't. It's functionally an arbitrary and capricious standard on the on what the Planning Commission did. So it's a higher bar essentially for overturn than in a normal preponderance of the evidence kind of case. Certainly, I will put that in a memo to you guys, but that's generally the standard that's applied here.
Well, thank you. I think that standard is important because essentially, I think we're now looking at saying the Planning Commission didn't do their job. And I know that in between the first appeal and then the second appeal, there's been mediation. So I just feel very uncomfortable with this whole situation and knowing how hard the Planning Commission has worked on this to just spend more time and wait for some time in June to have this hear this appeal. I think everyone deserves a speedy hearing, and I think that's what we should do. I think we need to stick with the April 8th date. Thank you.
All right, thank you. Just remind everybody that our task today is to reconsider whether we reaffirm or pick a new date. So that's the main focus. Commissioner Byrne, please.
Thanks, Mayor. Well, I guess I just want to echo what Commissioner Cluzzi said and perhaps comment on what Mr. Walton just described to us as the role. I think we need to be careful in how we describe our role out to the public so that people don't get different understandings and interpretations. Because my understanding is that the Delaware legal standard for overturning a lower body decision is that the lower body had to have been arbitrary and capricious, as you said, in making that decision. And to me, that's the role. And so without getting further into that detail, because we are considering the date, I'm all for, I think, a fair and speedy decision that benefits the entire community.
I'm giving a little bit of a shorthand, but I wanted to be very clear. The standard is derived from your own code. It's what the commissioners have adopted. So that's the reason that standard applied here.
Thank you.
Thank you, Max. Thank you, Commissioner. Commissioner Gossett?
Yes, just reacting to that in the aspect, I think that the oversight or comments about a fair and speedy trial are should be taken into consideration, but I think a feeling or something that comes a priority before that is due process. And I really feel that this is what we need to address. And again, the purpose of today's meeting is to review due process for the setting of the hearing date. Thank you.
Thank you. Anybody else? Well, I want to share that how I've been looking at this is strictly from the point of view is there adequate time for any of the parties to provide their submissions? I do not believe 4 days is enough time. And I'm not just looking at this case, I'm looking at future potential appeals. And I think a 4-day notice for them also would be too short. And that's why I'm going to favor extending the date for the hearings. I also want to pick a date to retain Max. I think it benefits us to have somebody that's familiar with all the parties and players and familiar with the previous appeal hearing. And as far as the request for the extension beyond 10 pages, I would like to just retain what we have and go with that. So with that, if there's no further comments by the commissioners, I would entertain a motion. And if the motions could be to retain the April 8th date for both hearings, the motion could be to rescind the date of April 8th and reschedule a new date, June 14th at 10:00 a.m. And the third could be to nullify the April 8th meeting date and to resume, to convene a future meeting and reset a new date with a new lawyer. Anyone willing to make a motion?
I will make a motion to rescind the scheduled date of Thursday, April 8th, and reschedule the hearing for Monday, June 14th, 2021.
I will second that motion.
We have a motion on the floor by Commissioner Gossett to rescind the April 8th hearing date and reschedule the 2 appeal hearings for Clear Space and Rehoboth Spotlight to Monday, June 14th. Do we need to set a time, Max? in this motion?
I think we said 10, I think you did say 10 a.m. if the motion.
Okay,
Second.
at 10 o'clock a.m. And we have a second to that motion by Commissioner Legree. Would like to do a roll call vote. Commissioner Richard Byrne,
Yeah, I vote no against extending the time. I've made some comments already. I don't want to repeat all of that. However, I think that we're setting a very bad precedent when we've already had a discussion and a vote on this previously, and that I think the precedent, could become, and I hope it doesn't, that a handful of residents can write well-intentioned letters. They have every right to do that, and that then we suddenly are pushed into a corner to make a decision that may not be in the best interest of all residents and of the entire city. So I vote against this motion. Thank you, Mayor.
thank you, Commissioner. Commissioner Gay,
I vote aye. As I've said before, I think this is the only, and others have said, I think this is the only fair way to go, not just for the appellants, but for all parties. They'll all be filing briefs. They all need time to do that. And I want to see, and in my mind, given this kind of proceeding, 60 days is well, and actually 3 months is actually pretty speedy in the grand scheme of things. So I just want to be fair to everyone, and I think that the June 14th date does that. Thank you.
thank you. Commissioner Gossett,
I vote yes, and I think we should be establishing the appeal schedule, which allows for the adequate consideration of all the issues and the parties, also the mayor and commissioners, for us to be able to prepare ourselves for that. And I also reflect back to our oath of office, where it states that we should represent all people and provides due process for all parties. Thank you.
thank you. Commissioner Calusi,
I will vote no. I would echo the reasons given by Commissioner Byrne. I would also say I don't like this process that some letters have been sent to the commissioners, and we've put ourselves in a position of having a public meeting that hadn't been noticed properly. And so I'm voting no.
thank you. Commissioner Legree,
I vote aye, and I think fairness is the best. We have a counselor who has background, history, knowledge of the case, which is going to help speed it up, and so I vote aye.
thank you. And the chair also votes aye for the reasons I stated earlier. So the motion carries 4-2 with one absent. I would like to address Commissioner Calusi's allegations of violating FOIA. By FOIA standards, this agenda fits the bill in terms of special meetings that are allowed to be noticed in under 7 days, as long as a valid reason is given. So I'm very comfortable with that, Commissioner Calusi. With that, yes, sir.
Mr. Mayor, may I just add one thing? I'm going to keep exactly the same thing that I already told the parties and just extend the date. I've told them that there will be no preliminary motions and that they will file their briefs on the schedule that's done. And I'm going to keep that in place. And I just wanted to be clear about that for the commissioners and whoever else is listening.
All right. Thank you very much, Max. Thank you for being here today. Thank you for letting us retain you. And with that, this meeting is adjourned. Thank you very much.